Have you ever felt totally helpless staring down a massive faceless bureaucracy? Or maybe you've actively dreaded the idea of trying to resolve a dispute simply because traditional courts just seem like this endless black hole of time and money. Well, welcome to this explainer. Today, we're going to take what might look like a dry pile of legal statutes and completely transform it into an empowering, real-world toolkit. We're going to explore exactly how everyday disputes and even deep-rooted systemic corruption are actually being handled efficiently outside of those slow traditional courtrooms.
Here's the agenda for today. 1. Beyond the traditional courtroom. 2. Speedy informal dispute resolution. 3. Investigating public controversies. 4. Fighting public sector corruption. 5. Protecting the truth tellers. And 6. Access to faster justice.
Let's dive right into Section 1, Beyond the Traditional Courtroom, the Justice Bottleneck. Right, so to truly appreciate the tools we're about to cover, we first really need to understand the fundamental bottleneck of ordinary court litigation. Traditional courts are incredibly expensive, they are highly technical, deeply adversarial, and honestly, they can drag on for literally years. Imagine a bitter dispute tearing apart a successful family business. If they go to a traditional court, it's an absolute war. Both sides bleed money, operations just halt, and the family ties, well, they're often destroyed forever. But informal methods offer a stark contrast. They're economical, speedy, consensual, and amicable. Because finding a quick, practical solution and actually preserving those crucial human relationships is almost always vastly better than entering a hostile, draining legal battle where even the quote-unquote winner ends up losing something vital. Moving on to Section 2, Speedy Informal Dispute Resolution, Fast-Tracking Disputes. Let's see how this desire to bypass the courtroom actually works for solving personal disputes peacefully and quickly through ADR, or Alternative Dispute Resolution. Let's start with conciliation. So this is a voluntary process where a neutral third party doesn't just sit back, they step in and actively assist the disputing parties. The absolute key word here is actively. Think of a conciliator like a hands-on peacekeeper in a really tense neighborhood dispute over property lines. They're going to step right between the hostile parties, lower the temperature, and directly suggest concrete, cooperative solutions to get things resolved right then and there.
Now contrast that active role with mediation. In mediation, the process is incredibly flexible and completely confidential, but the mediator takes on a very different persona. Instead of suggesting the answers, they act more like a master facilitator of dialogue. They make sure both sides are genuinely heard, but they absolutely do not impose a decision. The final outcome remains entirely controlled by the parties themselves. And this approach, it's fantastic for preserving delicate social and business relationships, mostly because the two sides are guided to work together to mutually agree on their own bespoke outcome.
And you don't just have to take my word for how vital these tools are. The Supreme Court of India itself has actively championed these specific methods. In the Salem Advocate Bar Association case, they highlighted ADR to promote real access to justice. And there's a staggering reason for this desperation. Indian courts are currently grappling with tens of millions of pending cases. A traditional lawsuit can easily outlive the people who actually filed it. So to prevent the entire justice system from collapsing under its own weight, these informal, speedy alternatives aren't just nice to have. They are absolutely essential for a functioning society. Section 3. Investigating Public Controversies, Systemic Accountability. Okay, so we've talked a lot about private issues, but the crucial question is what happens when the issue is a massive matter of public importance? Like, what if a major newly constructed bridge collapses, or there's some colossal financial scam draining public funds? Ordinary local courts might not have the bandwidth or even the specific mandate to unravel something that complex quickly. Well, under the Commissions of Inquiry Act of 1952, the government can appoint a temporary commission of inquiry. These are often headed by retired, highly respected judges, and they're tasked with investigating these massive public scandals. They follow a rigorous workflow. First, they investigate the facts on the ground, then they meticulously collect evidence from all corners, and finally, they submit a comprehensive report packed with systemic recommendations. Now, it's true that their proceedings are primarily investigative, and their final findings are technically recommendatory rather than strictly binding. But seriously, do not underestimate them. They operate with the formidable teeth of a civil court. They can summon uncooperative witnesses, demand the handover of highly sensitive documents, and force crucial testimony under oath. They possess the immense authority required to cut right through bureaucratic red tape, gather the unvarnished truth, and lay a public controversy bare for absolutely everyone to see. That brings us to Section 4, Fighting Public Sector Corruption, Institutional Oversight. Let's shift our focus to the specific statutory bodies designed exclusively to hold the powerful accountable when things go terribly wrong at the very highest levels. To combat the kind of deep-seated corruption that actively undermines democratic accountability, India established its own ombudsman framework through the 2013 Act. The concept of an ombudsman is actually a really fascinating piece of history. It originated in Sweden over 2 centuries ago as a specialized, independent parliamentary representative. Today, it serves as a completely independent, neutral authority dedicated solely to investigating complaints against public officials for corruption or administrative abuse. To ensure absolutely no one slips through the cracks, this jurisdiction is split spatially into 2 distinct tiers. There's clear, focused accountability at the union level through the Lopal. The Lopal oversees the highest echelons of power. We're talking the Prime Minister, ministers, MPs, and central public servants. Then, at the state level, you have the Loyayuktas, who are specifically tasked with monitoring and investigating state public officials. This dual structure ensures that whether corruption happens in a local municipal office or right up in the capital, there's an independent watchdog ready to investigate. Working hand-in-hand with the Lokpal is the CVC, or Central Vigilance Commission. Given strict statutory status back in 2003, you can think of the CVC as the apex watchdog of the government's internal machinery. They don't just react to scandals, they actively make sure the internal gears of government departments aren't rusting with corruption. They supervise vigilance administration, launch inquiries into suspected misconduct, oversee complex anti-corruption investigations, and expertly advise the government on exactly how to handle disciplinary proceedings against corrupt officials. Next up, Section 5, Protecting the Truth Tellers, Safeguarding Whistleblowers. All of the powerful investigative bodies we just covered, from the Lokpal to the CVC, rely on one deeply critical yet incredibly fragile element: information from the inside. Which brings up a very serious, quite literally life or death question. Who protects those who actually speak up against powerful institutions? I mean, it's a classic David versus Goliath scenario. Exposing financial irregularities or a dangerous abuse of power takes immense courage. For an ordinary employee, blowing the whistle almost always invites immediate, vicious retaliation, risking their career, their reputation, and sometimes even their physical safety. By definition, a whistleblower is a person who exposes this corruption, misconduct, or abuse of authority in the public interest. Imagine an honest civil engineer who discovers that cheap, faulty materials are deliberately being used on a massive public dam project. If they stay silent, people could literally die. If they speak up, they could be destroyed by the corrupt contractors and officials involved. To ensure transparency and give that engineer a fighting chance, the Whistleblowers Protection Act was passed in 2014, specifically to protect these incredibly brave individuals from facing severe backlash. This act is designed to be an impenetrable legal shield. It guarantees that exposing the unvarnished truth about government authorities or public sector organizations doesn't cost an honest citizen their livelihood. It legally insulates them against workplace victimization, relentless harassment, disciplinary retaliation, and direct threats to their employment or physical safety. It's the absolute crucial safety net that allows the truth to emerge from the darkest corners of an organization. And finally, Section 6, Access to Faster Justice, a Stronger Democracy. Let's bring all these distinct pieces together to see the ultimate goal of these laws. As championed by the Supreme Court in the landmark Vineet Narayan case, these aren't just convenient workarounds or temporary legal loopholes. They are vital, permanent statutory tools that strengthen democratic accountability. And why does this matter to you? Well, because transparent public administration means your tax dollars are actually safe, your local infrastructure is sound, and your society functions fairly for everyone, not just the wealthy or the well-connected. So we've seen a complete spectrum of tools today. Take Lok Adalats, for example, which translates to People's Courts. These were established under the Legal Services Authorities Act specifically to resolve everyday community disputes economically and swiftly, totally without the intimidating formalities of a regular court. From a Lok Adalat settling a neighborhood dispute over a weekend, all the way up to the CVC investigating systemic, multi-million-dollar corruption, this entire toolkit actively protects the public interest and saves incredibly valuable public resources. Since true justice isn't just a physical destination, it's not restricted to a slow, intimidating courthouse. It's actually an active, ongoing process that requires our awareness. So how will you leverage these empowering mechanisms the next time you face a frustrating dispute or witness a blatant abuse of power? I really hope this explainer has given you the knowledge to see exactly how these tools work and how they actively keep our systems fair, fast, and accountable. Thanks for joining me.